could start the recording. And with that, I want to welcome everyone to this event organized by the Institute for Feminist Legal Studies under the direction of Hangame Saberi, but also co-sponsored by a little workshop that I run called the Osgoode Colloquium on Law, Religion, and Social Thought. Professor Saberi asked me to introduce Dr. Zucker, and I'm very, very pleased to do so. I want to, though, begin by acknowledging that these issues we're going to be hearing about today are not just legal and theoretical, nor practical in any readily transportable kind of fashion. As Dr. Zucker will show, they take place in locations, in sites with material political histories and effects on how lives of communities are lived, continue to be lived, and will be lived down the road. So we must, and I do, acknowledge that these discussions and this kind of thinking about religion, law, community, the character of justice have long taken place on this territory, Toronto, which has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, the Huron-Wendat, and the Métis, and is now the home of many Indigenous peoples. I want to specifically acknowledge the current treaty holders, the Mississaugas of the Credit River. I think it's also important to note that this territory is subject to the Dish with One Spoon Wampa Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. Very much looking forward personally to this talk from Dr. Miriam Zucker. She's a recent SJD graduate of the University of Toronto Faculty of Law and earned her master's from the Hebrew University of Jerusalem, if I'm not mistaken. Her fascinating work is in the fields of multiculturalism and feminism, in law and religion more generally, constitutional law as a broad umbrella, with her particular focus being on intragroup vulnerability, particularly of minority women. And I'll say, as someone that works in related fields, certainly the broader law and religion space, this focus on intragroup vulnerability means that Miriam has made really an important contribution already in her scholarship to the theoretical literature in this area, calling the state to account for creating, in some instances, and certainly perpetuating this vulnerability that centers her research, vulnerability within religious groups. So I want to encourage you to look at her published work on these topics. You'll find that in the Columbia Journal of Gender and the Law, the McGill Journal of International Law and Legal Pluralism. And let me just close this brief introduction by saying just how very fortunate we are to have her delivering this paper today. And I hope you'll join me in giving Miriam a very warm welcome. Miriam, thanks so much for being with us today.
Thank you, Ben. So before we begin, I want to thank the IFLS and my fellow visitors for a very fruitful visit. I want to thank Professor Saberi and Liel for having me again this fall. And I also want to thank the Osgoode Colloquium on Law, Religion, and Social Thought for co-sponsoring this event. So thank you, Professor Berger, for your interest. So today I will talk about a new piece that I'm working on. This piece is part of a larger project that employs intersectional feminist analysis to critically examine demands that Muslim women unveil in public institutions like courts, at work, and other settings, exploring ways to challenge these demands. So in a series of cases since 2005, the European Court of Human Rights validated laws that ban different types of Muslim veils in several countries, including Turkey, France, and Belgium. The applicants in these cases were all Muslim women or girls who faced different sanctions because they were wearing their head or face coverage in public institutions. For example, a university student who was prevented from taking an exam because she was wearing her headscarf, school students who were excluded because they were wearing their headscarf in a physical education class, and a hospital social worker that her contract was not renewed because she refused to remove her hijab at work. In Sass versus France, and later also in cases that dealt with the Belgian law, the European Court of Human Rights found that France and Belgium's ban on wearing face covering garments in public places are not in violation with these states' obligations according to the European Convention on Human Rights, including the obligation to respect the right to privacy, the freedom of religion, as well as securing the enjoyment of these rights without discrimination. In these cases, the court relied on a problematic reasoning, ultimately accepting a new ground for limiting Europeans' human rights, the French-made principle of vivre ensemble, or living together. In each of these judgments, the court determined that the ban interfered with the right to privacy and freedom of religion. As common in human rights adjudication, the judgment focused on considering whether these interference could be justified under the limitation clause. The limitation clause in Article 8 and 9 of the European Convention demand that the interference with the guaranteed right is prescribed by law, pursues at least one of the legitimate aims specified in that article, and is necessary in a democratic society to achieve this aim. Now, let's have a look at the second paragraph of both Article 8 and 9. As you can see, both limitation clauses include as legitimate aims interests such as public safety, health, and the freedom of and the protection of the rights and freedom of others. Just a second, my cat decides to interrupt, sorry. I will not get into a whole discussion of the different arguments that the French and Belgian government invoked and their scrutiny. It would be enough to say that the court rejected attempts to justify the ban based on gender equality or women's human dignity claims, such as that the ban is necessary for protecting women from a practice which the concerned women, like the applicants, defend. It is also worth mentioning that in Sass versus France, the court ended up accepting the argument that public safety was one of the ban's legitimate aims. However, it determined that France failed to show that its blanket ban on full face coverage is a proportionate public safety measure. In addition to the object of public safety, the French government argued that the law pursues another legitimate aim: respect for the minimum set of values of an open and democratic society. France argued that the ban aims to secure core values of the French society, including that of fraternité or fraternity. It maintained that concealing one's face breaks social ties and manifests a refusal of the principle of living together. Therefore, demanding everyone under France's jurisdiction respect for minimum requirement of life in society is necessary to ensure the ability of the French society to live together. Now, let's look again at the limitation clauses of Articles 8 and 9. We will not find the words respect for the minimum set of values of an open and democratic society, living together, or anything of that sort in the list of legitimate aims which are specified. Exercising a kind of a judicial acrobatic to accept the French government argument, the court created the unheard of ground of living together and linked it to one of the legitimate aims listed in this limitation clause, that of the protection of the rights and freedoms of others. So let's see, this was the court line of reasoning. So I wanted to kind of to analytically show how analytically or not, the court got to this conclusion. So according to the European European Court, the face plays an important role in social interaction. Therefore, seeing other people's faces is essential for open interpersonal relationship and socialization. Given that seeing others' faces is a condition to socialization, citizens of the French Republic have no less than a right to live in a space of socialization. This is ultimately because seeing other people's face makes living together easier. Hence, letting practices of concealing one's face develop in public places would raise a barrier for open interpersonal relationship. The ban serves as a measure to prevent this barrier from breaching other individuals' right of socialization. Now, let's imagine that a citizen of a European country reaches Strasbourg after exhausting all domestic remedies to challenge the state law that mandates the wearing of face masks in crowded public spaces. The applicant claims that the law violates her right to privacy, together with discrimination in the exercise of this right under Article 14 of the European Convention, on the ground of her opinion against COVID-related restriction, which she believes are all government's plot. In fact, we actually don't need to stretch our imagination to consider how seriously the case will be treated. In several cases since November 2020, the ECTHR, the European Court of Human Rights, declared the inadmissibility of individual applications complaining about the handling of the COVID-19 crisis by their governments. The court decided that these applications failed to fulfill the admissibility criteria of individual applications under Article 34 of the Convention, which requires, among other conditions, showing a victim status. In other words, these applications were dismissed as inadmissible on the basis that the applicants were unable to show that they were directly affected by the measures complaint. Anecdotally, two of these cases concerned French national applicants who complained that their government violated their right to privacy, guaranteed under Article 8 of the Convention. But let's assume, for the sake of argument, that our face mask protester applicant managed to establish a victim status, as well as showing that the demand to wear face coverage interfere with her right to privacy. I want to leave in brackets that the fact that unlike niqab wearing women, our applicant is required to put on a piece of fabric rather than striping off a deeply meaningful garment, which is tied to her identity. The respondent state would likely succeed in defending the law as necessary in a democratic society for the protection of health in a time of global pandemic, and for the protection of the rights and freedom of others. Others' rights to life and security clearly come to mind. In this respect, our applicant, especially if she happens to live in France or Belgium, might invoke some sort of a counter argument. Drawing on the niqab case's judgments, she might argue that demanding people to wear face masks in public places raise a barrier for open interpersonal relationship, and thus interfere with their fellow citizens' right to live in a space of socialization. It would be interesting to think how the court will deal with its own creation of the condition of living together as an element of the protection of the rights and freedom of others. Especially considering that in SAS versus France, the court tried to deny the xenophobic or anti-Muslim order of this living together reasoning, when it pointed out that the court is aware of the fact that the impugned ban mainly affect Muslim women who wish to wear the full face veil. It nevertheless finds it to be of some significance that the ban is not expressly based on the religious connotation of the clothing in question, but solely on the fact that it conceals the face. In fact, even the sound of this living together argument against face coverage is awkward today. Setting aside that scientifically face coverage is considered essential for literally living rather than dying together, it also appears that seeing other people's faces is not so crucial for preserving conditions of interpersonal relationship, socialization, or living together. Ultimately, the interference in our applicant right to privacy is likely to be found justified, proportionate, and not discriminatory. It seems that if there is anywhere that the state should be afforded a margin of appreciation with regard to the necessity and proportionality of rights limitation, a doctrine which quite rightfully has been criticized as the graveyard of European human rights, demanding people to wear face masks in a time of a global pandemic would be an appropriate case. Examining the limitation clause adjudication of the ACTRESPECTING in the niqab bans cases reveals that the degree of depth and seriousness in which the niqab wearers' complaints were considered was not far off the way in which the ACTRESPECTING handled the COVID-related complaints and the expected way that it's likely to treat our face mask protester complaint, as I have sketched. In the niqab ban cases, the court identified the main issue as interference with the freedom to manifest one's religion or beliefs, but rejected the applicant's argument that the bans discriminate against Muslim women. Now, before critically examining the ACTRESPECTING's minimization of the ban's effect on Muslim women and the Western essentialist perspective that its proportionality analysis demonstrates, I want to kind of zoom out of the European context and discuss Quebec's religious symbols law, known as Bill 21. It seems that that we only need to kind of zoom out rather than turning our gaze to a completely different context. Because as we shall see, the Quebec legislator drew inspiration from the French term in the understanding of laïcité, as well as the European trend of banning the Muslim veils more generally. After the release of the Bouchard-Tyler report on reasonable accommodations practices in 2008, there have been several attempts to legislate on the neutrality of the state and prohibit religious apparel in Quebec. While the Bouchard-Tyler report is not the focus of this talk, it should be mentioned that these attempts, including Bill 21, were not exactly in line with the report recommendation, to say the least. For example, the report recommends prohibiting public servants who have coercive power from wearing religious symbols. This category includes judge, crown prosecutors, police officer, and the president and vice president of the National Assembly only. It certainly doesn't include school teachers, who are evidently the largest group affected by Bill 21. And yet, in June 2019, the coalition Avenir Québec, who initiated Bill 21, succeeded in passing it into law. The law, bearing the title of an act respecting the laicity of the state, demands that public employee in authority position, including school teachers and school principals, police officers, and government lawyers, remove religious symbols at work. The law also obliged civil service personnel to carry out their function with their face uncovered, with the exception of health reason or coverage required for performing their task. Finally, it demands receivers of these civil servant services to have their face uncovered where doing so is necessary to allow their identity to be verified for security reasons. To shield the law against constitutional challenges, the Quebec legislature invoked the notwithstanding clause. So far, Bill 21 has been challenged in the Quebec Superior Court. The court struck down certain parts of the law, however, kept most of it intact, relying on Section 33 of the Charter. The Canadian Liberties Association and the National Council of Canadian Muslims have already announced their intention to appeal the Quebec to the Quebec Court of Appeals, and it is likely that the case will end up reaching the Supreme Court. Obviously, unless the Quebec legislature invoked Section 33, the court would have required the Quebec government to justify the limitation on the affected individual's rights according to Section 1. In this scenario, let's assume that the court applies a considerable degree of deference and accept that Quebec's version of laïcité, or state neutrality, more specifically as a condition for laïcité, are real and urgent objectives of Bill 21. The government would then need to show that the limitations on the affected individual rights, freedom of religion, expression, and equality rights are proportional to these objects. The first feat that the Quebec government would need to overcome is demonstrating that Bill 21's bans are rationally linked to these objects. Now, I suspect that showing why prohibiting public employees in authority position, like school teachers, from wearing religious symbol apparel is necessary for achieving state neutrality wouldn't be an easy task, especially considering Article 16 of Bill 21, which protects the emblematic or toponymic elements of Quebec's cultural heritage, in particular of its religious cultural heritage. In simple language, this provision protects the crucifix and other elements of Quebec Christian heritage in its public institutions. But wasn't the Quiet Revolution about separating between the church and the state? Why does the presence of religious symbols on the body of individuals who work in public institutions interfere with Quebec's religious neutrality, whereas this neutrality remains intact when Christian symbols are displayed in the province public institutions? Why do symbols of the majority religious denomination simply become cultural heritage elements, which their public display does not interfere with state neutrality? The correlation between the bans and the alleged objective of religious neutrality seems coincidental at best. At worst, the line that Bill 21's proponents seek to draw between the bans and religious neutrality revealed xenophobic and anti-Islamic ulterior motives. First, as for the ban on religious symbols apparel, it is hard to grasp how does the state become involved in proselytization simply because school teachers and other public employees are wearing religious symbols, especially considering that these individuals belong to immigrant and racialized minority communities. In Quebec Superior Court's decision in the case of Ha versus the Attorney General of Quebec to exempt the English language school board from the application of Bill 21 due to the immunity of Section 23 from the overreach power, the court criticizes the attempt to justify the ban on this politicization ground and implies its prejudicial nature. Second, Quebec government would have to show why it's necessary that civil servants exercise their function without covering their face for achieving religious neutrality for non-health reasons. Let's, for the sake of argument, ignore the Islamophobic order that erased from this provision, which uses a natural language, but obviously target the Niqab. The provisional government would have no escape from demonstrating how does seeing a civil servant's face support religious neutrality. Since, as I have indicated, it is hard to imagine a sensible reasoning to support this claim, it is likely that the Quebec government would find resort in drawing on its Francophone sister argumentation about the importance of face visibility for managing diversity or living together. That is especially given the success of this argumentation in the ECTHR. The European case law are of course not binding or applicable in Canada. However, the fact that a highly respectable supranational human rights jurisdiction accepted this argumentation is perceived by Bill 21 proponents as having the effect which Frédéric Maigret described as deprovisionalizing the bill. I hope I'm doing justice. The inspiration that the Quebec legislator drew from France and other Francophone societies in Europe is implied in the Attorney General Quebec argumentation in the Quebec Superior Court. While the AGQ refused to present evidence or any argument relating to Section 1, he defended Bill 21 ban as not fundamentally different from the solution to these questions adopted by other democratic states, implying to the European bans. Also, the debate in Quebec's parliamentary committee have the similar air of urgency that surrounded the European bans, and they even refer to the French living together principle. For example, Minister Jolene Barrette, who spoke during these debates, mentioned that Quebec is a distinct society, can and must make its mark in its development of religious pluralism. As democratically elected parliamentarians who are accountable to the people, we have a duty to respond to the concerns expressed over the past 2 decades and to translate the popular will into pragmatic and balanced responses. To acquire a model of secularism, a common vision of living together is above all a choice of society. Indeed, unlike France and other European countries that favored a blanket ban on full-face veils across the public space, the full-face coverage ban of Bill 21 applies in the civil service domain only. This difference might have some significance. It could serve as a kind of a lifeboat for the Quebec government to jump on in an effort to survive a proportionality scrutiny of Bill 21. First, in terms of demonstrating a rational link between Bill 21's full-face veil ban and its real and urgent objectives. The fact that this ban is limited to the public service domain can be used to enhance the living together reasoning by arguing that there is especially important that civil servants' faces as the state representative are visible for maintaining religious neutrality as condition for living together in Quebec's diverse society. Second, in terms of the minimal infringement of rights, the fact that the full-face veil ban applies in the public service domain only increases its chances to pass this test. Now, let's assume that the Quebec government would manage to show that Bill 21's religious symbol and full-face veil bans are rationally linked to its object of protecting Quebec's model of laïcité by securing the province's religious neutrality. I suspect that if we are careful enough to consider what rights and public interests are at stake, Bill 21 cannot survive a proportionality analysis domestically under Section 1 or internationally under Canada's relevant international human rights regime, namely the International Convention on Civil and Political Rights, the CEDAW, and the case law of the United Nations Human Rights Committee on this issue, the HRC. Here I want to return to the ECTHR judgments in the Niqab cases. This is only to consider the possibility that after balancing all the rights and interests at stake, banning the wearing of religious face or head coverage in public institutions could be reasonably validated for the sake of advancing secularism and or as means to achieve state neutrality. I suspect that this possibility is very unlikely. To understand why this is so, I want to explain why relying on the ECTHR's reasoning, and especially its proportionality analysis, is a very weak footing. I suggest that the ECTHR limitation clause analysis went wrong not only because it accepted the unheard of ground of living together, but even more so because the court failed to consider the gender aspects of the bans and their adverse effect on an arsenal of Muslim women's rights and freedom, including liberty, freedom of movement, and equality rights. To say the least, it is hard to see how a serious consideration of the ban's adverse effect and the harsh impairments of individual rights and other relevant public interests that they involve could reasonably lead to their validation. It seems that a fair consideration of these impairments which was missing in the ECTHR judgments, couldn't lead to this result even if we allow the state a margin of appreciation. Rather than a margin of appreciation, it would have required the code to basically allow the state to draw on the whole page. The ECTHR judgment focused on the interference with the applicant's right to religious freedom. Therefore, this court limited the constitutional analysis to a competition between religious freedom and the alleged interest of living together, which is defined as a condition for protecting the right and freedoms of others. The ECTHR judgment focused on the interference with the applicant's right to religious freedom. Sorry, the ECTHR rejected, sorry. So we saw that the focus of the ECTHR was on religious freedom. Now, this court rejected with almost no discussion the argument that the Niqab bans violates Article 14 of the ECHR because they constitute discriminatory interference with the applicant's right. It determined that since it found that these measures has an objective and reasonable justification, it cannot be considered as having disproportional adverse effect on a particular group. Among other flaws in its reasoning, the ECTHR demonstrate a formalist, archaic understanding of equality and discrimination, and an approach which insists on ignoring some of the most obvious adverse effects of the veil ban on Muslim women and girls. In contrast, the United Nations Human Rights Committee, which is the relevant international human rights regime for Canada, took a very different approach. In two cases that involved French applicants, the HRC found that France's full-face veil ban violates the right to religion freedom and non-discrimination under the International Convention on Civil and Political Rights. Not only did the HRC rejected the principle of living together as a vague and abstract notion, which cannot serve as a legitimate objective for limiting this right, the HRC also deemed the ban disproportionate, recognizing some of its harmful effects as follows. The ban runs the risk of confining fully veiled women to their homes, impeding their access to public services, and exposing them to abuse and marginalization. This recognition led the HRC to the conclusion that the ban is counterproductive to pluralism and gender equality, and ultimately constitutes a form of intersectional discrimination based on gender and religion. Indeed, the HRC went a long way in comparison to the HCTHR judgments. However, I think that we should go deeper to unpack the way that the demand that Muslim women unveil constitute intersectional discrimination. To this end, using post-intersectional analysis to identify the intersecting forces of oppression could be helpful. The veils bans confront Muslim women with an unfair choice, which neither Muslim men nor Muslim women are required to make. Indeed, the veils ban interfere with the right to religious freedom in a discriminatory way because only Muslim women face the dilemma between following the religion's convictions or complying with the state law. But if we go deeper, I think that the demand to unveil constitutes intersectional discrimination because it involves intersecting oppressive forces that relates to Muslim women's identity, both as women and members of racialized minority groups. Unlike their male counterparts or women of the dominant religious groups, the demand to unveil in public forces Muslim women to choose between their citizenship rights and their culture, impeding their ability to negotiate between the two. Muslim women who wish to attain education or land a successful job are required to leave their known Western signifiers behind. Ultimately, the demand to unveil forces Muslim women to shed known Western elements of their identity as a condition to participating in public life and attaining Western notions of success. If they wish to keep these non-Western cultural elements, they should stay in the private sphere of the family. The demand to unveil as an entry condition to public institutions protects this division. This understanding of the harmful effect of these bans makes it plain why also more limited versions of the veil bans, like the hijab bans or bans that apply on public employee only, constitute intersectional discrimination, even if they hit less victims. For example, as evidence presented in the Quebec Superior Court show, all the job application files that were closed by the Centre de Services Scolaires de Montréal following the entry into force of Bill 21 concerned Muslim women wearing the hijab. In addition to the limitation on the affected women's ability to exercise their individual rights due to the access barriers that they create to public transport, education, healthcare, or employment in the public sector, the veil bans have further negative implications for gender equality, an object which Canada and other signatory states are obliged to promote according to the CEDW, the Convention on the Elimination of All Forms of Discrimination Against Women, and which is entrenched in Section 28 of the Charter. Now, I want to end with a brief conclusion about the implication of this analysis for a proportionality assessment of Bill 21. I suspect that even if we were to accept the notion of living together as a way of managing diversity and consider it as a legitimate object, the harmful effects of Bill 21 on Muslim women, as well as gender equality more generally, are obviously greater than its beneficial effects, if there are any. Thank you.
Thank you so much, Miriam, and very grateful for that talk. Professor Saberi, the director of the Institute for Feminist Legal Studies, who has organized this event, has asked me to just carry on from the introduction to do questions and conclusions. And so thank you, Hangame, for that. So I'm happy to open it up for questions. And I certainly have a couple to ask for Miriam's insight and knowledge on, but I'll hold those to first turn to the group here assembled for any questions you might have for her. So perhaps what I'll do is get the engine kind of pumping with a first question. Oh, wait, we have a couple of folks. So perhaps I can turn then to our host first to kick us off, Professor Saberi.
Sorry, thanks, Ben. Thank you so much, Miriam, for rich talk. I'm kind of hesitant to be the first person. I thought, there's no other raised hand, so maybe I should. I would have waited, but there you go. I was wondering, and tell me even if this question is simply doesn't make sense to you, if there are any other areas in which one can find analogies to discrimination, gender discrimination, in the religious context, or freedom of religion context, not probably to this degree, but, and you know that obviously I'm talking about, the quote unquote, in the liberal context, not in other contexts. Are there any other obviously more nuanced that what we see here, forms of discrimination that one could very clearly trace to gender, although other possibly other elements could be present as well? And so if you can think of any other cases, then I guess the reason I'm asking this question, the way to use that is, how would you compare the modes of argumentation in those cases? Do you see similarities, differences? In other words, is there anything that distinguishes the question of hijab in its different forms, partly because it's been politicized so much in the hands of the judiciary as well? Or no, you can actually draw similar links in other contexts as well, and so to speak, theorize it in a broader way. I don't even know if this makes sense, but if it does, I would be eager to hear a response.
Should I respond right away, or okay? So thank you for this excellent question, Professor Saberi. I actually think that there are similarities, maybe less, as you said, less obvious, but if we kind of go deep, we can identify them. So actually, as Professor Berger introduced, when he said in his introduction, my former project focused on the problem of intergroup vulnerability. And I see a connection between the two, because so my doctoral work and my publication deal with contexts of polygamy and forced marriage, and I think that, for example, in the context of polygamy, in a similar way, it's a very different context, of course, but what I think that that link this two issues is, for example, in several contexts, especially in the Israeli context, which I focus on, you can see how the state, how the Israeli state is involved in creating, in basically perpetuating this practice. And one of the major ways that Israel is involved in is creating discriminatory barriers to public services. Now it is very different, because I think that unlike polygamy, which is also a problem to say, if it's also problematic to say that all minority women are against this practice. It's a different topic. But I think that in the context of the Niqab, of the hijab bans, it is clear, like at least in Western countries, with immigrant communities, Muslim immigrant communities, it is clear that women who wear the veils, it's not something that is forced. Actually, research show that they often have to kind of resist the pressure of their family members not to wear the niqab. But I think that if we look at the bigger picture, the niqab bans disempower these women, and they harm their ability to negotiate between two words, their citizenship and their culture. And I think that this is where I also see that barriers, the access barriers that Israel is involved in creating for example, in the context of the Bedouin community. I see that link between the two. I think that it's a way that the state contribute to the vulnerability of women inside and outside their communities.
Thanks so much, Miriam. Appreciate that. And I see we have a couple of hands up. And so thank you for that response. And I want to make sure we can get to any and all questions. So Lise Mills, I think I'll turn to you next, if that's all right.
Well, let me just, here we go. So I suppose I should turn on my video because it's so important to see my face, as the European Court has said. So it's incredibly interesting to listen to you. And in South Africa, where I'm from, we've had a couple of interesting cases on this particular topic. Let me first start off to slightly just throw a spanner in the works here about the gender discrimination, because we've had an interesting case in our Labour Court where two men refused to shave their beards because they belonged to a particular religion, wasn't a Muslim, two Muslim men. They were, I can't remember what the religion was, but anyway, and they were employed by a security firm, and the security firm required them to be clean shaven when, they act as security guards. And the Labour Court actually found that this wasn't discriminatory practice in the context of what their job required. So that was one case. And then we had two other interesting cases of a girl, a Muslim girl who was expelled, well, school found her guilty of misconduct in terms of the code of conduct of the school because she was wearing a Muslim stud, a nose stud. Sorry, not Muslim, a Hindu nose stud. And then the other one was a case where a woman that worked for the South African National Defence Force was also required to take off her headscarf. She was a Muslim woman, and following a process of 3 years of court decisions, the SANDF, National Defence Force, actually changed their policy, and she is now allowed to wear a headscarf. So, so what is interesting, especially in the no-stat case, our Constitutional Court, very interesting for me to hear what you spoke about now, what the European Court termed as living together, where our court took slightly a different approach in saying that, you know, reasonable accommodation, this concept of living together, how difficult is it for, you know, for the school to make the accommodation that this girl can wear the heads after the nose stud? But I want to actually ask you, because this is where it wasn't raised in these cases of ours, but I want to know, I've not read the European court cases, the issue of the security, because it, excuse the pun, but wasn't it the reasoning also sort of in a veiled disguise, talking about, you know, security issues? Because I know there's also been instances at airports, you know, where women have to remove their headscarves or whatever. So was that not part of the reasoning by the European court? It was purely this, you know, how important it is to see the face, and that we have to live together, and everything that we're not doing at the moment with COVID.
So it was actually part of the discussion, but first, the European Court kind of questioned the sincerity of this claim of using this ground of security, because it looked at the parliamentary discussions. It wasn't the main. It wasn't even, you know, it was a very marginal issue. It kind of links to the kind of the procedural turn in the margin of appreciation, which I think this decision employ, but it was willing to accept it, but it wasn't. It didn't see it as passing the proportionality test, because it's not really. How can you explain, you know, the ban everywhere in the public space on security ground? It's just like what, or every Muslim, it's even this argument, it reveals anti-Muslim prejudicial strain of thinking, like what every Muslim woman kind of hide a bomb under her niqab. That's or you know, or you need to identify because she might be, you know, part of Al-Qaeda or whatever. You know, it's it just, if it was just in like I don't know, in the context of say a place that you actually need to recognize the person's identity, and okay, that makes sense, more sense at least, but not a blanket ban, I think.
Did you want to follow up, please, or can I turn to Lisa? You're good?
No, I'm good. It's Lisa actually. So Lisa, but it's just Lisa. So
I'm sorry, Lisa. Thank you.
But no, no problem. Thank you. Thank you very
know.
much for that response. Thank you.
I happen to know the next is Lisa, so I'm going to turn to my colleague Lisa Dufresne.
Hi, thanks, Ben. And thank you so much, Miriam, for that really interesting talk. I wanted to ask you about the relationship between the legal analysis that you've been talking about and the public understanding and discourse around these kinds of laws, because it seems to me that in Canada, the big problem is not establishing that from a legal point of view, these laws are discriminatory. That seems like an easy case. These laws are discriminatory on the basis of religion and on the basis of gender. And I can't imagine a really plausible argument that they're not, that would be legally salient. But of course, with the override in place in the charter, really what's important is what the population thinks about these laws and whether people are in support of them or not. And I wonder, like, I worry about the public discourse on this, because there's been, as you know, I'm sure in Canada, sort of a sense that even naming the discrimination associated with the religious symbols ban is somehow offensive to Quebecers specifically, or to those who are in favor of the law. And so politicians engage in a lot of doublespeak and soft pedaling on this issue. And in general, there's in some quarters at least, a real reluctance to engage in frank discussion about something that seems like an obvious case of discrimination. And so I wonder, the two questions I have, the first one is perhaps unfair because you're a legal scholar and this is really not your area, but how do you move public understanding of this sort of thing? Like that, because it seems to me that should be the goal to really solve this problem in Canada. How do you actually get through to people who are sort of unwilling to see the discriminatory character of the law, even though it seems sort of obvious? And then if that's too much of a sociology question and not enough of a law question, at least, what do you think is the interplay between the public discourse and the public understanding and legal discourse and case law in this area? So those are some of my questions. I hope they're useful.
Well, I think it's very useful, and thank you for this question. I'm actually, not only interested in I'm interested in public policy, and also, some theoretical aspect of these questions. But in terms of the public discourse, so I think that what is really disturbing about the use of the notwithstanding clause in the context of Bill 21 is that I think it's also a kind of attempt to block the public discourse, and because the court is part of this. So, like, I mean, you can't separate completely between the two. It's it's in the media, and people so I think that this is if Quebec were to just willing to that this law be examined, scrutinized by the court, this would be a different case. I think that it is difficult for the public. I must say that even for myself, if you take me I don't know, years before, say before I started the PhD, before I'm not thinking I was so against the Niqab and the Niqab bans. Like, I thought, oh wow, this is like, it seems like oppressive, the practice. The women need to cover themselves, and me as coming from Orthodox Jewish education, I must say that it kind of related to my feeling, that I hated that they kind of, I had to wear like a long skirt, and why, like, what's wrong with my body, and those Western kind of. But I think that if we don't allow the discussion, the legal discussion, I think that through that discussion, it's kind of the legal analysis, the legal test kind of force you to look at what is actually at stake if you're willing to kind of open, as not. So therefore, I think that, I read some opinions, for example, Rowan LAICI suggests to allow core allow declaration about that the notwithstanding clause will not block completely the ability of the court to review the law and actually show it to the people, because it's not, I don't think that it's enough there that people can actually, you know, they just, it seems like okay, we're a minority within the Anglophone, and we want to, like, is it you're forcing your values on us? But if we look, so that's, I think that the Quebec people in Quebec might feel, but if you allow this discussion to happen, they might see the you know, how it relates to also other kind of discrimination and darker days in the human history against other minorities. So yeah, that's my 2 cents about it.
Thanks, Miriam. I'm gonna ask a question, if I might, and maybe it follows on Lisa's in a couple of ways. And you'll forgive me just a second or two to kind of talk about my way into it. And so, you know, there is a literature on the bill and on the Quebec Niqab ban, and there's a certain character of some of it, which is to say, versions of the following. Here are the internal contradictions of the bill. Here are the irrationalities of the bill. Here are the consequences for discriminatory consequences or effects of the bill. You know, let's draw those into high relief and show them, and we'll show that this is a unjust bill, that it's ultimately not constitutionally compliant. And I think your talk is sort of in that mode, which is sort of saying, let me show you what's wrong with it and why it doesn't hold up to either a justice analysis or a legal analysis, to the extent that those differ in this setting. And I just wanted to get your reaction to a kind of alternative thought on this, about what's at stake here. And the alternative thought is that it's not the case that the drafters or those responsible for the bill here are deluded or less rational or less aware of any of these effects, but rather that the goal of this legislation wasn't and never has been constitutional compliance. That the goal of this legislation is not aimed at constitutionality at all. And so meeting it on the ground of saying this is unconstitutional and disproportionate in the following ways is sort of missing the character of what this bill is about. And then equally, that looking to European or other countries and transnational or international kind of universalist rights comparisons is missing what this other approach might think is central. And the other approach that might think is central is something local, specific, historical, which is, since Confederation, it's always been the case that Quebec's distinctive status and sovereignty within the nation has been done on the back, in part, of different ways of managing religion. So whereas at the founding of the country, that was, we're Catholic, rest of Canada is Protestant, that has, through many historical transformations, shifted to a moment of saying, in fact, we approach secularism differently than you do. You have this multiculturalist approach to secularism. We have this other approach to secularism called LAICITY, drawn totally anachronistically from our French origins. And so in this sense, the argument here is that actually the failure to be constitutional is in a sense, the point, that it's about not the law of the Constitution here, it's the politics of the legitimacy and the status of the Canadian Constitution and the Charter of Rights in a context of Quebec sovereignty that is the real point of this legislation. So that's kind of the alternative point, is that, like, you know, we're meeting it on the wrong ground when we do it this way. And so I wondered what your reaction is to that argument that's out there, that in fact, you know, talking about the comparators from kind of a universalist register is missing the constitutional politics in favor of the constitutional law.
I think it's I think it's a very good point. I kind of, the focus of my talk was about the intersectional discrimination that this measure creates and reinforce. But I think that the problem with this ground is that it has to be coherent, the argument there. And I think that even historically, we have a problem in Quebec argument, as well as the French argument. Because laïcité, as you say, it was about separating the church and the state, because the power that the church had over the lives. Whereas now, what happened is that it all turned against a minority group, and it seems that what actually I tried to kind of I did touch upon it in my talk, that I think that there's a kind of a spirit that you can see it over Europe and elsewhere as well, that there is a problem. The Muslims are it's threatening us. This religion is threatening us. At the end, you know, they require all our women kind of to dress up like that. You know, that's kind of the I think the spirit. It's a kind of a panic of a way of that you see that kind of the bill is, yes, it is about managing diversity, but a kind of I think Barras, her article talk about it, a kind of a preventative diversity, and we must do something about it, and it's everywhere in Europe, and I think that it relates to what we can see as a kind of retreat from multiculturalism across the globe in many in Europe. So I didn't touch upon it, but you can see that in Europe, countries like the Netherlands enacted a ban on the Niqab, and you see this trend, this kind of attempt in other places. In Australia, it's a kind of a panic, and I think we should be concerned about it, because it's not, I don't think, as far as much as respect I have for like Quebec, sovereignty, there are serious human rights implications, but not in terms of trend, not what it does to women, but it's kind of, I must say that I think that it's kind of, I feel like it's a pendulum that brings us back to to dark days.
Great. Thank you. I hear that. That's I think that's got a lot in it. So thanks for that, Miriam. Appreciate engaging on that way. So I see questions from Roshan and Juman. And so Roshan, if I could start with you, and Juman then turn to you. We have about 10 minutes left. So that's just to frame overall, so we can, all of us, calibrate how much time we have remaining. So Roshan, thanks for your question in advance, and please go ahead.
Thanks, Ben. Hi, Miriam. Thank you for your talk. I really, I found I learned a lot from it, actually. I'm not a legal scholar, I'm a political scientist. But I wanted to ask, sorry?
The two go together.
Oh, yes, they do.
Okay,
You're right. So I wanted to ask like two connected questions, but one, I wanted to ask about sort of what you think. I know this is not exactly this topic of your talk, but what do you think about sort of the erasure, I think, of the voices of Muslim women who wear religious symbols in these discussions, whether they are, academic, the public debates, and also some of the legal ones as well. You hear a lot of, people speak about Muslim women, but not really either letting them speak for themselves or speaking with them or making space for their contributions. So I wanted to ask about, like this reproduction of Muslim women as the objects of other people's discourses, whether it be well-intentioned discourses, but nevertheless, the erasure of their own sort of voices in that debate. And then alongside that, the absence also of, other people who are affected by these types of bans, whether they're European bans or, the ones in Quebec. Like we never hear about Jewish men who wear kippas, their experiences, how do they sort of experience bans on their sort of religious symbols being, not being allowed to wear them, or Sikh men, or even, the religious symbols of indigenous people in this country are never identified as religious symbols. So these types of erasures and absences, I just wonder, what do you think about them, and what do you make of them, and maybe how to overcome them? I think that might be a little bit, beyond the scope, but what do you think about them?
Roshan, thank you so much. And Miriam, I'm going to ask you to hold that while we bring in Jumans, and then you can kind of address them all at once before we close. Is that all right?
Yes, certainly.
Okay, perfect. So Juman, can I turn to you? And thank you again, Roshan.
Hi, thank you everyone. Thank you, Miriam, for the presentation. And I'm having technical issues with my camera, so
no problem.
Keep it off. I had an observation on the last slide, the one that dealt with the UN response to the European Court's justification. And while some of the parts seem true, I think if I recall the sentence correctly, it said that this justification might lead to prevention from access to public services and expose them to abuse. And here I kind of stopped for a minute to think that although the judgment or the approach was seemingly positive, there might be somehow a reproduction of the kind of violence and discrimination that it's trying to prevent in terms of essentializing Muslim men, or essentializing the kind of marriages or relationships in which this context is referring to.
So should I start? I'll start with the Juban question. So actually, thank you for this comment. I actually myself, at first I looked at it, it seems essentialist and problematic, but I'm not sure, and I need to review it again because I wanna make sure that I'm so I'm happy if you want to jot your email. I'll return to you, but I think that that was my initial response, and then I realized, and I hope I'm not overprotecting the ECR, but that what it means is that about not within the community, but in terms of the public, because the band often what they create is as antagonism and against Muslim women, and lead to their marginalization as a kind of unwanted, unwelcome beings in the public sphere. So, and there were a lot of cases of violence against Muslim women. So I think we should be careful, like, and see what exactly does it mean, it refers to. Though I must say that even though research, and I just think that we should not, that the approach should be very careful and contextual in these matters, because I think that as part of the essentialism is kind of putting all Muslim women under one group. So so I agree that the research and the major, find that women wear the attire because they feel it's part of they feel connection to God. They feel it's nobody forces them, if they even have to resist force against them in immigrant community. But it's not in every context the same. There are maybe some countries that it's different. Not every woman, if in the have the choice. So even if we kind of accept, and I totally reject the kind of the paternal kind of gender equality argument, that we just want to protect Muslim women gender equality by banning the, but it's actually counterproductive, even if we agree that there are some women that are forced to wear the niqab. What even if so, what it means is actually just confine them and not allow them to land a job, because even if they are forced to, okay, so then they have no, they are forced to wear it, and then they have no choice but staying home, right? So in both ways, this gender equality argument just doesn't hold. Okay, so just that's one thing. And now
a minute left.
Yeah, as for Roshan, thank you for this wonderful question. And it's I think it's fascinating. And I always feel like, as a Jewish woman, I always feel that I kind of need to justify my engagement with this thing as kind of, you're like talking for people. And I'm trying to avoid this trap and kind of, based on actually women voices and research about women voices. But I think that, yeah, that's another, actually, in terms of Bill 21, for example, yeah, Muslim women were actually excluded from the debate. Their voices were barely heard. So that's another kind of procedural turn to deliberative turn to the argument. Okay, so that's that's my comment to those wonderful questions. Thank you. It was really enlightening, and thank you for the great comments, which allow me a lot of food for thought.
Thank you so much, Miriam. And let me just say, of course, intrinsically, definitionally, much more to be said about these things. And so thank you for bringing us so deeply into the set of issues and the touchstones that you've laid out for us. Thank you again to the Institute for Feminist Legal Studies and their director, Professor Saberi, for organizing the event, and to Liel Gonzalez for all she puts into it. But the biggest thanks, of course, to Miriam Zucker for this wonderful talk. Before we give that warm thanks, I just want to note that Professor Saberi was kind enough to allow me to plug next Friday's Colloquium talk. So it's in the link there if you'd like to join for one of our talks again in the chat. But again, please join me in very warmly thanking Dr. Zucker for this fabulous paper and for the time together. Thank you so much, Miriam.
Thank you. Thank you.